Hello, my name is Orlando Prescott. I'm a circuit court judge here in Miami-Dade County, and I preside in our juvenile division. The juvenile court is designed for the redirection and rehabilitation of our youth. We have the jurisdiction of our children up until the age 19. One of the things I wanted to demystify about the system is it's not for punishment. Juvenile court is designed for just that, rehabilitation and redirection. When a child is arrested, the first place they're taken is to the Juvenile Services Department. Some of our families know the place as the JAC, but the JAC is designed for the intake of the child and for the assessment of the child. Once the child is released from the JAC, some children may be taken to the Juvenile Detention Center where they await their first appearance hearing before a judge. This is where you come in. Our parents and guardians are notified by the Juvenile Services Department and notified as to when to come to court. When you come to court for the very first time, that's called a sounding. At that time, the court will inform you as to why the child was arrested. They will also speak to you about whether or not you wish to hire an attorney, and then also determine whether or not the child will remain in secure detention or to be released back into the community under some type of supervision. If you desire an attorney for your child and you do not have the financial ability to hire one, we will give you a financial affidavit that you will fill out completely and truthfully, and that will determine if we appoint a lawyer for you. If we appoint a lawyer for you, your child will be represented by the office of Mr. Carlos Martinez. At that point in time, the court will also determine once again if your child is to remain on the custody status that they're on. Each offense in the state of Florida is assigned a number. If your child scores 12 points or higher, your child can remain in secure detention and the court has the authority to hold the child. Although the child may score 12 points or higher, the court still has the authority to exercise its discretion to release your child back to the community under certain conditions. At the sounding hearing, that will be discussed. If your child is released to your custody, the child is under your supervision and you're responsible to the court to ensure that your child returns to court at a later date. Upon the child's arrival at the Juvenile Services Department, assessments will be conducted. Those assessments can be utilized by you and the child at a later time to seek assistance. When your child is there, your child will undergo, or at least the personnel at the Juvenile Services Department will give your child the opportunity to have an assessment. Those assessments are not placed in the court file. The court doesn't see them. The assessments that your child undergoes at the Juvenile Services Department will be an indication as to whether or not your child needs further assistance. That assistance will be offered to you and the child prior to trial. You're under no obligation to accept it, but it is highly recommended that you accept those services for the betterment of your child. If the state should file a petition, which is the official charging document of the state, then the case will be set for a trial. The attorney that was assigned to your child, it's imperative that you and your child make an appointment to meet with that attorney so you can be adequately prepared to defend the case at trial. At the hearing, at the sounding hearing, the attorney will provide you their name and contact information. One of the first things that should be done is that you and your child should make an appointment to meet with that lawyer. If the case is set for an adjudicatory hearing, on the date set for the trial, it will be up to the state of Florida to present their witnesses at trial to try to prove their case to the court. Although a petition has been filed and the case has been set for trial, many of the cases are resolved prior to trial. Many cases don't go to trial. Your child may be offered a diversionary program, which means that either the case is suspended and conditions are placed on your child, and if your child successfully completes those conditions, then the charge will be dropped and the case will be dismissed. Other times, the state may offer your child a plea to the charge, whereupon if you enter the plea, the child could be placed in a program here in Dade County. They still remain at home, but if they successfully complete the terms and conditions of that program, then the charges will be dropped. If a petition is filed and your child proceeds to trial and they are found delinquent, meaning that the court believes them to be guilty of the charge, the court may place your child on probation. If the child is placed on probation, they will be assigned a probation officer. And after the adjudicatory hearing, you'll be given the name and contact information for that probation officer. It's vitally important that after the hearing, you make contact with the probation officer and meet with the probation officer. They will take history and ask questions about your child and compile a report that will be utilized by the court and by the attorneys to determine what sanctions should be placed on your child. If the child is placed on probation, they will be under the supervision of the court, and they may be under the supervision up to the age 19. That is our jurisdictional limit. The conditions that will be placed upon your child will not be for punishment, but for corrective behavior and corrective sanctions. At the initial hearing before the court, when the court appoints a lawyer to represent your child, if the court determines that your child is eligible to remain in secure detention, by statute, your child cannot be held for more than 21 days in secure detention. On the 21st day, the child will be released back into the community under your supervision, pending the disposition of the case. During the course of the case, while you're awaiting trial, if you should have any concerns about the behavior of your child, I need you to understand that the attorney that has been assigned to your child is the child's attorney. I've explained to you that if the child scores 12 points or higher, the court has the authority to keep the child in secure detention. However, if the child scores anywhere between 7 and 11 points, the court has the authority to release the child back into the community under certain conditions. One of the conditions that the court may place is that the child be placed on home detention. That home detention will indicate that the court has only authorized the child to go to school and to return home unless stated otherwise. Under the home detention, there's a Department of Juvenile Justice personnel who is assigned to your child to ensure that your child is complying with home detention. That person may call your home or visit your home unannounced to ensure that the child is complying with the court's order. If you have any concerns about your child's whereabouts when the child is on home detention, they will provide you with a telephone number and a contact personnel that you should call. One of the procedures that is conducted at the Juvenile Services Department after the child has been arrested is the fact that your child will be fingerprinted. The fingerprints are officially on file, even if charges are not officially filed by the state. Each arrest of a child becomes a part of that child's permanent record. However, there are mechanisms by which the record can be sealed, meaning that no one of the public will be able to see it, or expunged, being eradicated as if it never happened. The sealing or expunging of a record can be discussed with the attorney after court once the case is finally disposed of. Even if charges are not filed, these services are still available to you and your child. The Juvenile Services Department can assist you in making referrals to community-based organizations that can assist you and the family to preclude situations like this from happening again. Please take advantage of a wealth of information that is at the Juvenile Services Department. Call and your family can be assisted in any way, shape, or form.